Welcome back to Radio Entrepreneurs. I'm Jonathan Freedman. Our next guest in the hot seat, I shouldn't say guest, our reporter, Marc Z, with a Marc Z Moment. Always good to see you, Marc.
Thanks, John. Great to see you. Great to be with you. And it's never a hot seat when I'm hanging out with you. It's always very
De
comfortable.
Definitely not, but you're always bringing us timely and topical words from your everyday encounters with candidates and business owners. And what do you got for us today, our ace reporter in the field?
Well, what I thought I would talk about was as a lot of people are reading, and we've been asked by a number of candidates in the last few weeks about the federal layoffs. And also, people don't seem to understand. They're like, well, wait a second. They're talking about when the government lays people off, they have 60 days notice. But do I get 60 days notice because I've been laid off before, or they're having pending layoffs with their firm or company? And I just wanted to sort of clarify things that um, we're Massachusetts and many states nationally are it's
At
you
will,
don't
at
have
will states.
it's an at-will state. And so what I was going to say is that unlike where you have a 60-day notice, which I'll explain, when you're hired on for a position, it is at will. And a lot of the letters, confirmation letters, or that's something that's reminded to employees, you're at will. Now, in a lot of
At will
cases,
being that either party has the ability to terminate the relationship when they choose.
correct, correct,
Yeah, and I think often what people get confused by is law versus what is responsible from either
right.
side.
Right.
So,
Right. You could be right. You're an at-will employee, so absolutely from the employer-employee standpoint, you don't have technically the responsibility of giving notice. Employers don't have the responsibility of giving you notice, but there are usually repercussions, or like, for example, if there is a layoff, then there's severance that would be involved that the employer would usually offer, or the employee, if they're laid off, is eligible for unemployment. So there are alternatives, even though that's their status. Now, what the 60 days notice that you're reading about is that the it has to do with the Worker Adjustment and Retraining Act that was enacted in the 80s. I think 88. I'd have to check, but I believe that's the date where if you're an employer of 50 people or more, 50 to 100, 50 to 500 people, then you have to give a 60-day notice if you're going to be laying workers off within a 30-day period. And
okay.
if
So it
if
only
the
applies, it's not, it has nothing to do with the federal nature of it. It's the size of the company.
Right, well, it depends. Like, for example, it's a federal law, but a lot of the states have their own. They call it the WARN Act. Have their own WARN Act. And if you're a company that has over 500 or over employees, then it becomes down to laying off a percentage of the employees. It's not a hard and fast rule, but that's when the act would kick in. As long as you have a certain percentage, usually like 33% of the workforce or something like that. So
This may be getting a little too technical and a little too deep in the weeds here, but okay, I know we've talked in the past, we've talked about the individual situations and transparency in terms of hiring, some of the practices and some of the laws that are coming into place. But if somebody has an individual employment agreement, and that's getting into a whole area of, whether employment agreements are enforceable, etc. But if somebody has an individual employment agreement, would the terms of that agreement supersede anything that might be in a mass layoff, or does a mass, what I call mass, a larger layoff, usually supersede what might be in an individual labor agreement?
well, if it's negotiated, for example, if they do have an agreement, they say if that says, for example, if the agreement is terminated, the employee is eligible for certain compensation, or if the agreement is terminated, there'll be some arbitration to determine what the employee would be allowed under the agreement. Or, like, for example, um, that they would be paid a certain amount of money if there is a termination before the contract or the employment ends. So a lot of times, if an employee is laid off, they're eligible for not only unemployment, but they're eligible for severance potentially under the agreement, or it's something that's negotiated after there is a termination or a layoff. So it would again, you have certain rules that yes, it would not apply if you have an agreement, because an agreement does not necessarily have to anything to do with the layoff process.
So it's interesting. I mean, again, we're talking about what the law is, and then again, what is good practice to have in a firm. And today with so much being public knowledge about hiring, firing, people using various whether it be social media or platforms, Indeed, etc., to comment on companies, Glassdoor. There's the legal process, and then there's what's good for your business, and carrying out practices that you want to be known as a responsible employer. But
Right,
sometimes things do take a turn for the worse or turn south, and we've seen marketplaces dry up practically overnight because of some external influences. I
right,
think we're living in a time of some volatility where depending on what industry you're in, you could be facing costs that are 50% higher overnight, and may have shifts in your employment and staffing, etc. So I think it's great advice. So
but
people
can
are
I
are
tell you
looking.
something?
Yes.
No, what I was going to say is that, for example, great point that you make. During the COVID period, there were a number of firms and companies that laid off at least 50 people, and they did give notice to their employees that this was coming, and then they worked out a severance agreements that they were offered to the employees with being responsible employers. And those were cases that were very, very difficult because of COVID. Some people later got rehired, but those were examples of cases where you had 50 or more employees within that 50 to 500 range, where the employer had to give some kind of notice to the employees. And who thought that it was going to kick in to the professional services like it did in other different related industries?
Yeah, I think I think one of the things that we're seeing in in everyday occurrences today, again, I think a general rule of thumb is if you're going to do something, do it consistently across a labor
Right,
pool. Don't single out
right,
certain groups or certain people and do it different for them, because that's what creates problems.
right.
As a class of employees, they should all be treated equally.
Right, and that's why, that's why there's been a lot of misunderstanding about the 60-day notice. And but in the end of the day, as you said, it's treating the employer and the employee, treating each other fairly, and especially as employers continue to grow their operations and are looking for talented people. People are going to look at in terms of retention and in terms of how the employers were in uncertain times.
Good stuff, Mark. Always talking about timely, topical, things that are right on the pulse of what's happening in the marketplace. Mark, if people want to reach out to you, talk to you more about either offers they're getting or opportunities, or seeing what's coming down the pike for them, what's the best way for them to reach you?
First of all, John, go to our wonderful Radio Entrepreneurs website, radioentrepreneurs.com. Google Mark Z, M-A-R-C, and the letter Z will come right up. Mark Z Legal, MarkZLegal.com, and 617-338-1300.
You've been listening to a Mark Z Moment on Radio Entrepreneurs, and we'll be right back with another segment on Radio Entrepreneurs.